Hello, this is Tony Jenkins and welcome to this eCPD module which deals with taxpayer information notices. In this module you will cover information notices, the restrictions thereto and pre-authorised information notices, the penalties and the Tager case. This module will be relevant to all accountants. As an introduction, in a system of self-assessment, it is essential that the tax authority, HMRC, has the power to obtain information to be able to execute their responsibilities for managing the tax system. The information powers are a necessary power so that HMRC can check, where appropriate, the details that taxpayers include in their tax returns. The HMRC Compliance Handbook Manual has extensive detail on information and information powers. This module looks at the information notices, the penalties, and the first case on tax-related penalties, the Romie Tager case. Starting with information notices, general powers were introduced in Schedule 36 of the Finance Act 2008 to give HMRC the ability to police the self-assessment system. Some of these have been subsequently modified in other acts. The provisions included at Finance Act 2008 Schedule 36 Para 1 enable an officer of HMRC to require a person to provide information or documentation where that information is reasonably required for the purposes of checking that person's tax position. See the notes for the definition of tax position. Finance Act 2008 Schedule 36 Para 2 enables an officer to require a third party to provide information or documentation where that is reasonably required for the purposes of checking the tax position of a person whose identity the officer knows. Finance Act 2008 Schedule 36 Para 4 provides that HMRC must give a copy of any third-party notice to the taxpayer to whom it relates. The Tribunal can disapply this requirement if it is satisfied that giving a copy of the notice to the taxpayer could prejudice the assessment or collection of tax. Finance Act 2008 Schedule 36 Para 5 extends this third-party information power to enable an officer to obtain information or documentation reasonably required for checking the tax position of a person or a class of persons whose identity he does not know. A notice under Para 5 can only be issued with the approval of the first-tier tribunal. Paragraph 5A was inserted by the Finance Act 2012 and extends HMRC's powers to request information from a person about another person or class of persons whose identity can be ascertained. A notice served under Para 5A may only be issued under certain conditions. 1. The information is reasonably required to check the taxpayer's tax position. 2. The taxpayer's identity is unknown, but sufficient information is held from which the identity can be ascertained. 3. An officer has reason to believe that the person will be able to ascertain the taxpayer's identity from the information held, and the person obtained relevant information about the taxpayer in the course of a business. And 4. The information cannot readily be ascertained by other means from the information already held. The right to appeal. Finance Act 2008 Schedule 36 Part 5 enables appeals to be made against information notices issued under Finance Act 2008 Schedule 36, Paras 1, 2, 5 and 5A. However, an appeal cannot be made against the requirement in a taxpayer notice or a third-party notice to provide any information or produce any document that forms part of the taxpayer's statutory records. Finance Act 2008, Schedule 36, Para 32(5) provides that a decision of the first-tier tribunal on an appeal against an information notice is final. See the notes for the decision in Jordan and in Coldwell Concrete Flooring. Procedures before the first-tier tribunal. Finance Act 2009, Section 95 and Schedule 47 amended Para 3 and 5 to make it clear that applications by HMRC to the tribunal for the approval of taxpayer notices and third-party information notices may be heard ex parte. Finance Act 2009, Section 95 and Schedule 47 also amended Finance Act 2008, Schedule 36, Para 6 to make it clear that there is no appeal under the Tribunals, Courts and Enforcement Act 2007 against the decision to approve a notice. Let's look at the restriction on the use of information notices. Of particular importance to practitioners are the circumstances in which notices can be used which are no longer restricted by reference to a particular inquiry. The key point is that the tax position which can be subject to a notice includes a taxpayer's past, present and future tax liabilities, as well as penalties or other amounts which may be payable in connection with any tax. Consequently, Schedule 36 notices can be issued before tax returns have been filed or for historic years when returns are closed. Notices in respect of historic closed years can be issued only where an officer has reason to suspect that an amount of tax which ought to have been assessed may not have been assessed, that an assessment has or may have become insufficient, or that a relief from tax may be or has become excessive. In respect of non-resident capital gains tax, NRCGT, returns, such notices can only be issued where an officer has reason to suspect that an amount that ought to have been assessed has not been assessed, or that an assessment has become insufficient. It is not necessary for an inspector to make a discovery assessment in order to obtain information in respect of a closed period. There has to be a real and sensible prospect of a discovery assessment following the provision of the information. An information notice may not be issued speculatively in the hope that information showing an underassessment may crop up, or even in circumstances where an underassessment realistically might be identified. The key is whether or not an officer can realistically show, in the absence of the information sought, that there is sufficient evidence to show that there is a reasonable prospect that the information sought will enable an underassessment to come to light. Pre-Authorised Information Notices. A mechanism exists under Finance Act 2008, Schedule 36, Para 3, enabling HMRC to obtain the consent of the first-tier tribunal to the issuing of a notice under either Para 1, a first-party notice, or Para 2, a third-party notice. These provisions broadly mirror the provisions of the Taxes Management Act 1970, Section 20, under which an ex parte application for approval to the notice or the issue of a notice was made to the former General or Special Commissioners. In Revenue and Customs Commissioners ex parte a taxpayer, HMRC applied to the first-tier tribunal under Finance Act 2008, Schedule 36, Para 3, for the approval of the giving of certain third-party information notices. In the course of the first-tier tribunal's considerations, it looked at two specific points of law, and as Judge Berner considered these points to be of general interest, he decided to publish the conclusions reached. See the notes for details. Alignment with international information powers. Finance Act 2008, Schedule 36, was further amended by the Finance Act 2012 to bring HMRC's information powers into line with the international standard for the exchange of information for tax purposes. It concerned ways to ensure that HMRC can collect information in specific cases where the full identity of the taxpayer is not known, but can be ascertained by reference to other available information. Amendments were also made to the Finance Act 2008 Schedule 36 by the Finance No. 3 Act of 2011 Schedule 24 to extend Schedule 36 to tax of other countries to reflect international obligations. See the notes for the detail of the amendments. The new provisions allow HMRC to require a third party to provide information about a taxpayer if 1. The information is reasonably required for the purposes of checking the taxpayer's tax position. 2. The taxpayer's identity is not known to the officer, but the officer holds information from which the taxpayer's identity can be ascertained. 3. The officer has reason to believe that the third party will be able to identify the taxpayer from that information. 4. The taxpayer obtained that information in the course of carrying on a trade. And 5. The taxpayer's identity can be readily ascertained by any other means from the information held by the officer. Moving on to penalties. Where the recipient of a notice fails to comply with the notice, including concealing, destroying or disposing of documents, or obstructs an officer of HMRC in carrying out an inspection approved by the first-tier tribunal, a penalty of £300 is chargeable. Following the imposition of an initial penalty, further daily penalties of up to £60 are chargeable for each day on which the failure to comply or obstruction continues. Penalties are assessed by HMRC and an appeal can be lodged to the first-tier tribunal in respect of either the imposition or the amount of the penalty. A penalty will not be chargeable where the recipient of a notice or person subject to an inspection can demonstrate that they have a reasonable excuse for non-compliance or obstruction, or where the failure is a failure to comply within time limits, but compliance took place within further time allowed by an officer of HMRC. Penalties for non-compliance or obstruction are payable within 30 days of notification of the penalty being given, or within 30 days of an appeal against the penalty being determined. Penalties will be enforced as though they are amounts of income tax charged in an assessment. Moving on to tax-geared penalties. A further significant penalty provision under Finance Act 2008 Schedule 36 Para 50 enables HMRC to charge a tax-related penalty where there has been failure or obstruction and the revenue or HMRC have reason to believe that as a result of the failure or obstruction, the amount of tax that the person has paid or is likely to pay is significantly less than it would otherwise have been. Para 50 1C. Penalties are determined by the upper tribunal on application from HMRC in an amount decided by the tribunal by reference to the amount of tax which has not been, or is not likely to be, paid as a result of the failure or obstruction. A penalty under paragraph 50 is charged after the initial £300 penalty and is chargeable in addition to the initial and any daily penalties. Penalties under paragraph 50 must be paid within 30 days of the date of notification of the penalty and are charged in the same way as income tax charged in an assessment. See the notes for comments made in the Court of Appeal in the Tager case. See the notes for the comments on destruction, etc. of documents. Let's look at the Tager case. Revenue and Customs Commissioners versus Tager, personal representatives of the estate of Tager deceased, was the first case in which the upper tribunal considered an application by HMRC for the imposition of a tax-related penalty under Finance Act 2008, Schedule 36, Para 50, for failure to comply with information notices. The facts of the case are described on the next slide. The upper tribunal considered this case on 3 occasions. See the notes for details of each of these. The facts in brief were: the taxpayer, a barrister, submitted his tax returns for the years 2008-2009, 2009-2010 and 2010-2011 in April 2012. HMRC were not satisfied that the returns were correct and issued information notices. The taxpayer supplied only some of the documents requested. HMRC therefore imposed penalties under Finance Act 2008, Schedule 36, Para 39 and Para 40. As a result of his father's death in 2005, the taxpayer was liable to pay inheritance tax. HMRC had issued an information notice in relation to the inheritance tax return, but the taxpayer failed to comply with this also. HMRC applied for permission from the upper tribunal to impose tax-related penalties under Finance Act 2008, Schedule 36, Para 50 for his personal tax returns and the inheritance tax return. The tribunal decided to give the taxpayer a last chance to respond fully. Despite assurances that he would comply with the notices, he failed to do so. HMRC therefore returned to the upper tribunal. And finally, what the Court of Appeal said. In Tager versus Revenue and Customs Commissioners, the Court of Appeal set aside the upper tribunal's above decision. The Court of Appeal ruled that it was wrong for the upper tribunal to have drawn a comparison between penalties under Finance Act 2008, Schedule 36, Para 50, and Finance Act 2009, Schedule 55. Finance Act 2009, Schedule 55, provided a prescriptive tax-geared system of penalties where an error had been deliberate and concealed, whereas the only requirement in Para 50 of Schedule 36 of the Finance Act 2008 is that the upper tribunal must have regard to the amount of the tax unpaid, and it was never argued that the appellant had been guilty of conduct of that nature. The Court of Appeal remade the decision, reducing the penalties to £200,000 for inheritance tax and £20,000 for income tax. In summary, the key things to remember from this module are why information notices are required, the details regarding restriction and pre-authorised information notices, the penalty provisions and those relating to tax-geared penalties, the details of and the decision in the Tager case. I trust that you have found this module, which deals with taxpayer information notices, the penalties and the Tager case, informative. Goodbye, and thank you for using Croner eCPD.